Good morning, everyone. It's a pleasure for me to be here today. Thank you all for attending. It's so good to meet you all and gathering the antitrust community in person once again. It's so good. I'm so happy to see friendly faces, to have everybody safe and healthy here. So it's my pleasure to be here. We're looking forward to a productive and lively debate today, so let's get started soon. Thank you to all my partners in crime here, or not, maybe not. Commissioner Lenisa Prado, CADES Commissioner, teaches at the Instituto Brasiliense de Direito Público, IDP, where she also earned her master's degree. She's also a PhD student in tax law at the Federal University of Minas Gerais. Macon Delharin is an attorney, former head of the Antitrust Division of the U.S. Department of Justice, and currently part of the board of directors of Osiris Acquisition Corp. He also teaches at the University of Pennsylvania. He holds a Doctor of Law degree from the George Washington University. Sabine Zigelski is a senior competition expert at the OECD. Before joining the OECD, she was a senior case manager at the Bundeskartellamt, the German competition authority. Sabine graduated in economics from the University of Berlin. To introduce the subject, we'll first look at case law regarding the exchange of sensitive information from three different perspectives: the Brazilian, the American, and the European ones. In Brazil, CADE has never ruled specifically and solely on the exchange of sensitive information as an independent conduct. Commissioner Lenisa will correct me if I'm wrong, but in all of the cases on which CADE ruled on the exchange of sensitive information, they were each related to a cartel conduct. Either it was a way to support the cartel or as a part of it, but it was never revealed, and thus the case was a cartel issue, with some aspect involving proper exchange of information, but there was no case involved only the exchange of information itself. Europe and US already faced this issue. Under American law, exchange of sensitive information is not considered as an antitrust conduct by itself, but may be an element informing a cartel accusation. Europe, on the other hand, considers it an anti-competitive offense by itself and has ruled on several cases convicting companies for the exchange of sensitive information, even if it does not constitute a cartel. It will be great to hear and debate all these widely different fields. Commissioner Lenisa, the floor is yours. Thank you.
Hi, good morning. It's a great honor to be here today. And for that, I thank Ms. Patrícia and everyone involved in the organization of this event. I thank everyone for your kind patience. And I already say I'm sorry for any mistakes I may do in pronunciation. And sometimes we get lost in translation, but I will do my best. Yeah, the first disclaimer I have to give is every opinion and every personal comment I make on my presentation now does not represent or consolidates the opinion of CADE. So, as Patrícia said, initially it is very important to state that Brazilian competition law nor the penal legislation have listed the exchange of sensitive information as an infraction or as a crime. So the only written mention is found in the second paragraph of Article 107 of CADE's internal statute. Although this article, it is related to gun jumping, that crime that occurs when the consummation of mergers before the antitrust authority reaches a final decision, not characterized as an independent conduct. Different constructions may be found in CADE's enforcement practice, and it's through the only decision that it has been mentioned. As an example, in the aftermarket case that I will detail in the next slides, and the superintendents define, and here I quote, the exchange of information between competitors typically involves sharing specific information that directly deals with the performance of an end activities of economic agents, and I close the quotes. The main goal of this presentation is to understand how the Brazilian Antitrust Authority examines the exchange of sensitive information, so up until now, and if this conduct can be considered as an independent anti-competitive illicit. So this practice, it's not a very black or white situation, because it can benefits or risks to the competition and to the consumers depending on the circumstances. On one hand, increased market transparency is perceived as a factor to be encouraged, because the ideal model of perfect competition is premised on the demand side and supply side perfect information about the market, all based on the rational choice theory. But in the other hand, increased transparency is one of the facilitating factors required for tacit collusion to be sustainable. Moreover, the exchange of information may take various forms as a part of a wider price fixing or market sharing agreement, as a part of a broader cooperation agreement, such as a joint venture, and as a standalone practice. Regarding the third form described, a paper derived from the OECD Competition Committee debate in 2010 listed the most common ways for companies to establish flows of information as an independent conduct. I'm sorry, for me it's the letters are too small. Let me just see if I have the correct slide. No, let me come back. Is that what? Well, first, direct exchange between competitors as the most obvious and straightforward way of exchanging information and data. Secondly, antitrust agencies all around the world have investigated cases of vertical exchange of sensitive information. This is the so-called hub and spoke arrangement, where the information flows takes place through a third party. For instance, from one retailer to the other by their common suppliers. Well, CADE has already decided on hub and spoke cartels, in some aspects, but not directly mentioned as a exchange of sensitive informations. And the English clause is inserted in this context, whereby customers have an obligation to disclose to the domain company the existence of competing offers and to inform the dominant company of the terms and conditions of such offers. Well, the dominant company has the right to match the competing offer. So this conduct is the creation of an artificial market transparency, because the dominant firm is fed with information from the other competitors and about the market and the situation that led to the forming that price that is competing with itself. Well, exchange through trade and industry associations also is recurrent practice in different markets, and this we have been frequently submitted through CADE, but in the recent precedents, we can see that association may not be taxed as illegal, because discussions are legal in association and is the perfect ground to establish some interpretation of laws. For example, there was a recent precedent in CADE where I understood that the association was formed and was doing analysis of the new tax laws that would influence the formation of prices, but in no way this could be could be described as an infraction or as a crime, because everyone knows that the Brazilian tax system is one of the most complicated ones in the world. So when people receive the news of a new law, probably they will end up with the same difficulties, like such as how to calculate this new tax and what is the broadness that includes the basis of the taxation. So this is my opinion, and I emphasize that it's my personal opinion about the associations or syndicates, okay? So it is crucial to distinguish the regular dissemination of information aimed to elevate the efficiency for competitors and consumers from those cases where the dissemination underlies a conspiracy between the members. Due to these fine lines, extra safeguards are recommended. Finally, the referred document from OECD describes the dissemination of market data by independent third parties. Independent consultant, as Nielsen, for example, monitor markets and collects, compiles, and sells industry data and market studies to the market players. Yet, competition agencies are more reluctant to sanction such activities since there is no real exchange of information between competitors. Although this service, that is, this service that Nielsen, for example, provides, guarantees a constant source of crucial information. So although it is a legitimate business, we need to analyze if the response and the consequences of this data could cause an impact, a negative impact on the markets. Well, as an exercise to define the exchange of sensitive information as an independent anti-competitive conduct, the main doctrine indicates three factors: the structure of the market on which the participants of the exchange are active, 2, the type of product to which the information refers, and the type of quality of information exchanged. Analyzing these categories should help antitrust authorities to classify the potential harm of such exchanges between companies and to provide a safe ground to punish where harm is due. So, collusion is easier in concentrated markets because its fragmented market companies have more incentives to deviate from illicit agreements as they try to gain market share. Furthermore, monitoring deviations is harder in markets with more competitors. Regarding the product, price collusion is easier to reach, monitor, and sustain if the collusion is constructed around homogeneous products. Well, the last factor that is there is characteristics of the information exchange. Well, when the subject matter, confidential information regarding prices, qualities, and such is more relevant to competition law enforcers than public available data. About this, I have to say that although in some cases it is very hard to define the line that separates the legal public data from the illegal product of the exchange of sensitive information. I have to say that because in some markets, it is very common for one player to provide its prices to the other because we are treating about a dual market system. For example, in some situations, one player is the provider and the other is the consumer. And in the next operation, this exchange So it is very easy to be aware of the prices and qualities of products depending on the market that we are analyzing. Well, moreover, the dissemination of aggregated data usually is not restrained by antitrust agencies because there is some legality in providing, for example, information about the prices that is practiced. But it must be considered on case-by-case situations. Referring to the age and reference period of the information exchanged, authorities generally are more concerned with exchanges of data regarding future strategies, including price sales and capacity trends. Well, now we go to the very first case. Let me start by saying that this was the only case where CADE effectively judged conduct on the premises of exchange of sensitive information. On October 3rd of 2011, the former Secretary of Defense of Economic Defense initiated an administrative proceeding to verify the occurrence of cartel that supposedly happened from 2003 to 2009 in the optical disc drives, also known as the ODD's international market, which affected companies and consumers in Brazil. In 2019, CADE's court tribunal, recognized that cartel existence and applied significant fees for those involved. And for our presentation, this is an important precedent as the tribunal recognized that one of the companies did not participate on the cartel scheme, but solely engaged in a sensitive information exchange. Regarding Article 46 of antitrust law, the term of this type of conduct is 5 years, and the most recent document obtained during the investigation was dated from August 2005. So the conduct was declined because it was prescribed on 2012. And this case was decided in June of 2019. Well, we highlight the excerpts of Counselor Paulo Burniers and a conselheira Paula Farani, because they explained in their analysis some differences that must be taken into account in order to sanction a player because of exchange of sensitive information. According to the votes, as the information exchanged was about performance and quality targets, which does not involve necessarily prices, supply, or market division, they could not find any signal of attempt of collusion or cartel. And it is important to note that Consular Paulo Burnier emphasized that there were certain types of information that once shared have the same effect as a cartel. For example, I think here. But he did not see this happening in this specific case. Other representatives, other people that were investigated in this procedure were punished by the conduct of cartel, which also involved confidential information exchange. So in this case, although CADE mentions that might be a possibility of sanctioning, it was duly overlapped. Well, let me go to, okay. So first, let me make a disclaimer that this case is still under CADE's scrutiny, although the information that I'll bring here today does not represent any decision, but solely an analysis content in the public documents that integrates this proceeding. Bom, The investigation is about a conduct that was supposedly perpetrated from 2003 until 2016. The exchange of commercially and competitively sensitive information included, but was not limited to, a series of aspects. And here I quote, like revenue, prices, capacity, productive, sales levels, price adjustments, commercial structure as the number of representatives and their salaries and benefits. Well, there was a lot of information that on the account forms the business that is investigated. The interesting point of this case is that were celebrated 9 cease and desist agreements between the superintendents and some of the investigated. And in this cease and desist agreement, the representatives recognize the exchange information as the main conduct, as this argument is used to explain the rate that was adopted by the superintendents for the punishment between 5% and 12%, as determined in the CADE's diffuse cartel guide. In this case, the superintendency understands that there is no cartel evidence, as the exchange information intend only to establish uniform sales, logistics and marketing strategies, but the products were not the same and did not compete with each other. Another case that is still under evaluation of the court, but it has public announcements, is the aviation insurance. In 2019, an administrative procedure was established to investigate the aviation insurance market. There were strong clues that occurred exchange of commercially and competitively sensitive information through emails, telephone calls, and meeting information about slips, terms and conditions negotiated for insurance and reinsurance contracts, and specific confidential information such as insurance brokerage fee and insurance premium. The information exchange between companies were highly detailed and disaggregated, including actual price strategies, which gave them notorious competitive advantage. This procedure is still under investigation in CADE. Well, so in conclusion, it is, what I have to say is that CADE does not have a high number of precedents about this yet. Although we can foresee that in the near future, we will be able to define the grounds to justify the sanction for exchange of sensitive information. And it is common to see in, the superintendents, PROCADE, and even in the manifestations from the court, that we use and we try to be very near to what OECD has to say about this type of infraction. And factors to identify sensitive information exchange as an independent anti-competitive conduct are always, or at least up until now, frequently related to market structure when we are dealing with concentrated markets, products with the information refers when we are analyzing homogeneous products, and the quality of information exchanged, like if it concerns the future strategies, including price, sales, and capacity trends. So I'm here to say that this topic is not closure. We have not yet a very defined orientation on what it may turn in the near future. But what I have to say is the lack of legislation is specifically appointing what this infraction is, can cause and probably will result in some different precedents in the future. So we are dealing with a gray area that may be clarified in the future, but is only speculation here.
Thank you, Lenisa. Megan, would you share with us how U.S. treats the exchange of sensitive information?
Sure. Thank you so much for the invitation to be with you this morning. My only regret is not being in Brazil, and unfortunately being in the DC area. Let me just step back. U.S. law, as all of you know, does not prescribe specific conduct. It is very generalized. So the best we can glean is through the various precedents through our Supreme Courts. As a general matter, we treat exchanges of sensitive information on its effects on competition, and particularly, the experience over the years has been with the exchange of sensitive pricing information, whether it's the price of the product or the costs. And there hasn't been, our Supreme Court, I think the last one was in the late 70s, 78, 79, with the last Supreme Court decision that expanded, some of the types of conduct that would be limited. So let me say one thing. It's that, there's the types of conduct that we would treat as a cartel and the concerted action. And this would be if there's an exchange of information in furtherance of an agreement for price, which we would treat, criminally. If there is, that type of cartel activity, that would be price fixing amongst horizontal competitors. Outside of that, the exchange of sensitive information could, one, be used as not in and of itself as illegal, but it could be evidence, and in past cases has been shown evidence of a concerted activity and illegal, of a conspiracy in and of itself. On the civil side, the exchange of the information itself, sensitive information, can be okay if a couple of conditions are met. And this is a general rule based on the Supreme Court decisions. This is Container Corporation of America and U.S. Gypsum, two of the last cases that have discussed this. And it is, if it's not likely to have an effect on competition itself, if the exchange of information itself is not likely to do that, and one definition is if the price of information tends to stabilize prices, and that was the Container Corporation of America case, the court has frowned upon that and found that to be illegal. So if it does not affect the market conditions, then the exchange of information can be okay. Second, it's that you could still have the exchange of information, sensitive information, if there is a legitimate purpose for it, even if it does have a competitive effect. And by legitimate purpose, in one, it was the cement manufacturer's case where the court found that there was, the purpose of it wasn't to exchange information in order to stabilize price, but it was intended to prevent fraud, customer fraud that was going on. So, later on, there was another case where they said that, they needed, in order to meet a different statutory provision of the Robinson-Patman Act, and therefore the exchange of information was there. The court said no, there was less restrictive means by which to provide that and comply with the other statute. So I think the best way to encapsulate it is that you have to be careful if you're competitors of exchanging sensitive information, because even if by itself is not illegal, it could be used as evidence of a conspiracy. It's a plus factor, assuming other conditions are met. But if it does not have an effect on price, And even if it is okay and it is legal, the other is if it does have an effect on competition, then if you have a legitimate purpose for providing that information, then you still get a pass at doing it. Probably the two best general guidelines I could refer, some of the audience to, that the agencies, the Justice Department and the Federal Trade Commission have had, is one is in the healthcare guidelines that were issued. There's some specific guidance about when it would be okay to do such exchange of information. A lot of times these are done through, a trade association or some third party. The other is the most recent one on the human resources, on the labor one that the DOJ and FTC put out maybe 5 years ago or so. And both of those have some general guidelines. And I think the four factors, I'm taking this from the healthcare guidelines. They say that the information of sensitive information can be exchanged if, one, it's done through a third party. This could be a government agency. This could be a body, a trade association, or some other third party, not necessarily amongst the competitors themselves. Second, it's old information. So it's not the forward-looking or contemporaries, but in that one specifically, if it's more than 3 months old. Third is the kind of the concentration within the market. There is at least 5 participants in that type of an exchange of information, but no single one represents 25% of the data, 25% market share of the data that is being used. So the more concentrated you are, the greater the risk of antitrust harm. Finally, that the information is anonymized or is an aggregate form where you don't know specifically who is charging what information. If those conditions are met, then the agencies take a pass on that. Whether you still have some private litigation risk is a different story. But in a nutshell, that's what the status of the law is in the United States right now. Now, there's some different legislation that is being considered, whether one of those end up speaking on the issue of exchange of information outside of the digital platforms. I would doubt it, but the best guidance we can get is from the courts. Hope this is helpful.
Thank you, Macon. Sabine, I would appreciate if you could share the rich experience of Europe about it.
Thank you very much, Patrícia, and I'm going to try to share my slides. There we go. Hope you can see them full screen. Okay. Well, thank you very much, Patrícia, and thank you very much for having me. And I share the feeling with Mike, and my big regret is that I can't be with you in the room. I'm very jealous of all of you being able to be together. So hello from my solitary room in Paris, which isn't the worst place to be, but it would be so much nicer to be with you. I've listened with great interest to what Commissioner Lenisa and Macon said, and I think in the end we're not that far apart when I'm now going to present you the European perspective on information exchange. And like my fellow speakers, I would like to outline that I'm speaking in a personal capacity. So whatever I'm saying is not necessarily the opinion of the OECD or any of its member countries. What I want to do in the next 15 or so minutes is to introduce you how Europe deals with information exchange, and it is a concerted practice, and I want you to understand that concept and European law a bit better. I will then go into when is it a restriction of competition by object, by effect, and some case examples, and if we have time, possibly what's next on the agenda. Now, before I'm going into what is possibly an illegal type of information exchange, let me just tell you, in order to avoid that there's a wrong impression created, that European law fully recognizes that there is a lot of efficient and beneficial information exchange also in the horizontal relationship. So it can do a lot of good, not everything is bad. And that is very well recognized, in particular in two-block exemption regulations that we have for research and development agreements, for example, or for specialization, and some other types of agreements as outlined in the European Commission guidelines on horizontal restraints. For vertical agreements, the treatment is even more lenient. We have specific rules for those, and there's a lot of safe harbors provided for exchanges in that vertical relationship. What I'm going to focus on now is, as it was asked, talk about information exchanges that are a standalone infringement. So that are not part of a cartel agreement, in that they're facilitating the agreement, the agreeing on terms or monitoring of compliance. And I will also not in this part speak about indirect exchanges, so hub and spoke types of collusion, which obviously also involve a lot of information, and also put aside unilateral signaling type of information exchanges. So the focus is really on when is information exchange a standalone infringement, and that it can very well be. Where are we looking for it? Information exchange isn't really mentioned in the European law provisions. Article 101 of the Treaty on the Functioning of the European Union is where you would look for it. And that says that agreements, decisions by associations, or concerted practices by undertakings, which have the object or effect of restricting, distorting, or preventing competition, will be illegal. And if we're talking information exchange, concerted practice is what you want to look at in order to put it under this provision. And so what's a concerted practice? And on all of this, what I'm talking about, we have long and consistent case law, so that's a nice change for once, which is really like reiterated over and over again. And so it's pretty reliable, and you can rely on this being used the next time around, probably. So what's a concerted practice? That is when there has not yet been reached the stage of an agreement, but competitors have knowingly substituted practical cooperation for the risks of competition. And in a horizontal relationship, this can be a violation of competition law. What's the basic expectation we have when it comes to competitors? Well, each economic operator must determine independently the policy which they intend to adopt on the common market. This certainly allows them to adapt themselves intelligently, and all this is direct quotes from like very basic judgment on this matter. So of course they can adapt themselves intelligently and look left and right what their competitors are doing. This is the very purpose of competition. You want to be better, so you look what others are trying to do. However, what you must not do under European law is to get into direct or indirect contact with the competitors, the object or effect of which is to influence their conduct of on the market, or to disclose your own planned conduct to them. So that is strictly precluded. The European Commission has put this together in their guidelines, and they say, well, information exchange, if we look at all this, constitutes a concerted practice if it reduces strategic uncertainty in the market and thereby facilitates collusion. If the data exchanged is strategic. So sharing of strategic data between competitors is consultation because it reduces their independence on the market and diminishes their incentives to compete. Obviously, we're in the agreements part, or where people arrange or collude with each other, so that kind of implies the existence of reciprocal contacts. However, that condition is already met, again, long-standing case law, when one competitor just discloses its future course of action, its intentions on the market to another competitor, if that one requests it, or at the very least passively accepts it. That's sufficient for there to be a concerted practice, because it's sufficient that by such a statement, the uncertainty as to the future course of action on the market is eliminated, or at the very least substantially reduced, and that puts unilateral disclosure of strategic information fully in the concerted practices box. Now, this is how we can define what's a concerted practice. In a second step, it still needs to be determined if that has actually restricted competition. So that's logically a second step. However, and if we're determining if something is a restriction of competition by object or per se infringement, then we have to look at the market as such and the overall context of this behavior. But for certain types of exchanges of information, again, European Commission's guidelines on horizontal restraints, we assume that they are object restrictions, and that's the exchange regarding future prices or quantities. They will be treated as restriction of competition by object. They are considered as being injurious to competition by their very nature, and they would normally be considered and find as cartels. So they are equal to cartels, even if it's just information exchanges. And on top of that, they're very unlikely to meet the conditions for an efficiency defense, which is possible. So that's kind of the rule of reason analysis under European law. But it is very unlikely that this would ever work. If we have such an exchange, and that's really when it is a standalone infringement, forward-looking price and quantity data in particular, then we don't need to prove, for example, that there is a direct link between the practice and consumer prices, because European law protects the structure of the market already and competition as such. No need to show prices have increased. No need to show a direct link between data exchange and wholesale prices. It is sufficient to show that the information exchanged concerns factors that are relevant to pricing or in general to conduct on the market. No need for the exchanges to be continuous and regular, even, and certainly depends on the circumstances of the case, but if the circumstances are fit this type, then even a single exchange of information is sufficient, and I will have a case example for that a bit later on. Also, the people who agreed or who exchanged the information on the pricing did not necessarily have to have the ultimate capacity to set pricing in their companies. It's sufficient that there was a capacity by this information flowing within the company to influence the price setting later on. What about subsequent conduct on the market? Well, generally, a concerted practice implies that there is conduct on the market pursuant to these collusive practices, the concerted action, and the relationship of cause and effect. However, and that's where it's getting a bit easier for the enforcer, the prosecuting authority, there's a presumption that if such really harmful information, future-looking price quantity information is exchanged between undertakings and they stay active on the market, that they will take this information into account. So a presumption that we have conduct and a relationship of cause and effect. It's a rebuttable presumption, but that will certainly be hard to do in many cases. And that puts the enforcer, obviously, in a relatively comfortable position. Is it necessary to prove intent? Nope, that's long settled case law. Intent doesn't hurt the case, but it's not necessary to show. And that's when exchange of information is an object restriction, and that's relatively easy to do, even though these cases take years, as many do. Any other type of information exchanged is not necessarily injurious by its very nature. And then it will have to be considered under the effect standards, and that what brings us closer, if I understand correctly, to the US practice. And then, of course, we look at all these factors that Commissioner Lenisa has already outlined in her presentation. Then, of course, it is very important to look at what does the market look like. Is an exchange of information likely to lead to collusion? Is it a rather oligopolistic market and so on? You know the criteria. And then, of course, it's absolutely necessary to look at the characteristics of the information exchanged. What do they talk about? Is it forward-looking? How relevant is it to competition on the markets? Are individualized data exchanged or aggregated data? And what's the age of the information exchanged? This will certainly also all be very relevant. And for these cases, it's, as in all cases, always possible to bring an efficiency defense. It might just be easier and more likely to do that in an effects case. Now, coming to my last slides, just a number of little case examples. It's big cases, but I'm trying to really boil them down to the very essentials to illustrate what I'm talking about, and also the serious fines that have been imposed on these cases. So information exchanged is not to be taken easily in terms of fines that can be imposed. The one case I promised, the T-Mobile Netherlands case, was a case by the Dutch Competition Authority, but it went to the European Court for preliminary ruling. And in that case, the five, basically all mobile phone operators in the Netherlands, had exchanged at one single meeting information on their future pricing intentions. And that was standard dealer remuneration for postpaid mobile phone contracts. And here the authority, and then later on the courts, found this was evil. It was price related, and they exchanged once, but it was bound to have an effect on the market, even though it was not necessary to show effect, because that was deemed to be fully by object restriction, and the fine imposed of 60 million on these mobile phone operators was confirmed. Another case was the Fresh Del Monte, or the Dole case, the banana case. You find it under a number of different headlines. Here, every Wednesday, 3 banana importers would exchange information on market conditions, the shipments from Latin America, the weather conditions in the farming regions, and intended quotation prices for the sales later on with the big retailers in Europe. That was all pre-pricing communications, bilaterally, but lots of parallel bilateral communications. The employees engaged didn't have ultimate price setting authority, but of course, the information influenced within the companies what kind of prices or quotation prices would be set. And that, confirmed by the European Court of Justice, the highest instance court, this created conditions of competition that did not correspond to normal market conditions, and competition was seriously distorted. A fine of 138 million was fully upheld in that case. Now, you might think these fines are already interesting. Well, it gets more interesting. And we had in the financial markets cases, very interesting fines. 2019, the latest, the foreign exchange trading information exchange fine of 1.07 billion euros in 2 settlement decisions, where the Commission fined 5 large banks for taking part in 2 cartels, spot foreign exchange market for 11 currencies. And the traders involved of these different banks exchanged information in dedicated Bloomberg chat rooms that they had created, and that related to orders, prices, and open risk positions, and so on. So one of these chat rooms was named the Essex Express and the Jimmy, because these traders also happened to meet on the train to London from Essex, except for one Jimmy who was living in London, so he was added. So they had very funny names for these chat rooms. However, the practice wasn't found to be funny by the Commission, resulted in this very high fine. It was topped by the Euribor and LIBOR cases a bit earlier, which are still under appeal, where a fine also for information exchanges by object infringement was imposed of almost 1.4 billion euro. And then just one tiny case from the UK, which reminds me of the optical disk drive case that the Commissioner quoted, very similar constellation, I think, only that here a fine could be imposed, no limitation periods. In that case, the suppliers of steel water tanks had colluded, full-blown cartel, and they were fined for that separately. However, one supplier, Balmoral, did not participate in the cartel. Balmoral was invited to one meeting. They wanted to bring him into the fold. Would have been so much nicer. But they did not join in the end. But in that one meeting, Balmoral participated in the exchange of information, discussed the market, current and future pricing intentions, and didn't distance itself from the exchange of information. And that resulted in a fine for illegal information exchange by the UK's competition authority of 130,000 British pounds. And I think that's a practice, even though UK is no longer part of the European Union, is unlikely to change. Now, just 1 minute. What will the future bring? We're currently seeing a revision of the horizontal block exemption regulations and the guidelines on horizontal restraints by the European Commission. I don't think that the guidance with regard to information exchange will change substantially because it is grounded in very consistent case law. We will see additional guidance, possibly on the treatment of information exchanges between suppliers and retailers that are also competitors, online sales to think about, for example, where that happens more and more and where there is considerable uncertainty. You may expect guidance on competitor collaboration related to ESG goals, more guidance when it comes to digital issues, data sharing, and of course, something that possibly or will stay interesting in the future is also what do we do with information exchanged by algorithms? Algorithmic collusion is the topic here, but that's certainly for another time. And with that, I stop and look forward to the discussion. Thank you.
In summary, we've heard a lot. So in a nutshell, to organize our discussions, yes, what is necessary? What are the requirements for the exchange of sensitive information to be considered as an anti-competitive conduct? Must participants be competitors? All of them holding dominant position. Is the use or not of the information received a requirement? What about usefulness? Does the information need to be useful? Is intent a factor to be considered? Sabine has already answered this question. No, not at all. Are there types of information that are clear violations while others can be considered as a safe harbors? Sabine, can you start, please?
Yes, happy to, and I will be relatively short because I addressed lots of that already in the presentation. So under European law, it's relatively clear. Any type of information that reduces the strategic uncertainty between horizontal competitors will be a problem. And if it's prices or quantities forward-looking, it will be a standalone by object infringement. And then no need to prove effects, no need to prove intent. And there's also basically for this kind of hardcore exchanges, no safe harbor in Europe. So while we have exemptions and there are safe harbors, these are the type of hardcore restrictions that basically explode your safe harbor. It will not exist any longer. So basically that's the situation.
Yeah, we saw it. Weather conditions kind of concerned me a little bit. Macon, can you please comment?
Sure. With respect to the effect, it is any, if it has an anti-competitive effect, not just limited to price. So the cases we have seen deal with price stabilization, but it could also deal with issues of output, or limiting innovation or choice. So all the panoply of the types of anti-competitive effects that we would recognize in the law, we would look at the ultimate effect of that exchange of information. As far as exemptions, we have a handful of statutory exemptions in our laws, some limited to agriculture under Capper Volstead. Of course, there's some information under what's called the filed rate doctrine, where if it's required under certain kinds of other legal regimes, it could be the justification that would exempt this from that. And also you have, if there's involved as part of an effort to change government processes. So, the Noor-Pennington doctrine for the antitrust laws. But those are, they have their own contours and specific tests that you have to meet in order to meet that exemption. There really isn't a generalized safe harbor in our antitrust laws. The best is the type of guidance that is provided in the healthcare guidelines. For example, if it's old information, gives you some comfort. It doesn't preclude, a private lawsuit. But ultimately, you're looking at what kind of effect in the marketplace it will have, and whether or not you have a legitimate purpose for doing so. So you can have, future cost information even allowed under our regime if it was demanded by the customers. If it's information the customers need to meet, future supply demands and information. So that could be okay, even if it has a price stabilizing effect. So that could be the type of justification that is allowed under our rules.
Lenisa, your opinion between having effects and only all kinds of information. What's your opinion on that?
Well, I think that due to the lack of legal definition of the infraction of exchange sensitive information, I think it all comes down to proofs. We have to prove the damage that were caused by this dialogue, and in order to apply or think about sanctioning the parties. And I think in Brazil, we have to consider the intent of the exchange of information, because in some cases we may face situations where the players have obtained the sensitive information throughout other means that other than the dialogue with its competitors. So I think in Brazil, what we have to be very aware is the quality of the proceedings in regard to obtain this valid proofs that this exchange of information caused some damage on the market, Although I have to say one thing that I think it's very peculiar to Brazil. In some senses, we have a very high standard of transparency in, for example, public biddings. So I think that we have to be very aware that a lot of sensitive information is being obtained through licit means. So I think in Brazil, everything is very confusing. And I cannot say with some kind of definition what it will be and what should be considered an infraction. But I think the proofs, the quality of the proofs are essential to define the conclusion. So it means case by case, right?
Great. What about sanctions? The exchange of information itself is not a cartel, even if it's considered as an independent conduct or a part of a cartel case. So how might sanctions be defined? Is it a criminal offense? Is it comparable to a soft cartel? Is jail time applicable? Can you start in this time, please? Megan? I think you are mute.
There we go. The exchange of the information is typically, treated under the rule of reason in the United States. The government does not have the authority, unless it's criminal. We do not have civil fine authority in the government, so that's largely left to the private parties, which is very healthy in the United States. They get treble damages but you have to prove that there was an actual damage that is caused by the conduct. So if, let's just say, it's a highly concentrated industry and information on, future pricing is exchanged, and, let's say your sneaker providers or whatever, there's, 4 participants and they're exchanging information and it is having a price stabilizing effect. You have to show that you as a purchaser, as a direct purchaser in the US, would be able to show the actual damage harmed, and then you can recover from the participants. But the government itself, unless it's criminal activity, does not have the authority to impose any kinds of fines on the parties.
Sabine, please.
Thank you. It's relatively easy to answer, I thought first, because most European jurisdictions and the European competition law as such, we only know administrative fines. There is no criminal sanction for cartels, except a few exceptions. UK clearly also has a criminal enforcement regime. So that means it's almost always fined as an administrative offense. And you will see a differentiation, however, I think in terms of the level of the fines. So in general, the maximum level would be up to 30% of the relevant turnover affected by the cartelized conduct, the information exchange conduct. But that's really the upper bound for a hardcore cartel. Many information exchange cases, you will see that competition authorities stay well below the 30% and will fine more in the range of 10 to 15%. So there is some degree of adjustment to the gravity of offense here with the fines. However, it should be kept in mind that also under European competition law, a number of jurisdictions do fine bid rigging in procurement as a criminal offense. And I'm grateful for the Commissioner for mentioning that. Indeed, here information exchange can play a role or can be the constituent element of that exchange. And in that case, this could be considered criminal. So individuals could be fined criminally, but I'm not aware of a case where it was really, strictly speaking, just information exchange in such cases. Also an interesting argument that you brought, saying, well, in our public procurement system, there is a lot of transparency anyway, and we can see the prices that are being offered. And that's a very interesting thought. And here, I'd just like to mention the OECD's bid rigging work, where we very frequently really recommend to countries where we go and review the procurement laws to try to kind of fence in the transparency. Transparency is very good in principle, but it can be overly transparent in that it provides opportunities for collusion, in particular when the market structures are very narrow oligopolistic markets. So there's a balance to be struck, but just as an aside here. Thank you.
Can I add one thing on that, because I think that's really important, and it's a big focus in the United States, is the public procurement process. As you know, it's now 2 years, I guess this week is the 2-year anniversary of the procurement collusion strike force that I launched at the Justice Department. That it goes beyond just antitrust. It is, I think it's a little over 20 U.S. attorneys now. It involves the Department of Defense, the CIA, the Departments of Transportation, all of the inspectors general. And what you find a lot of times is that if there is kind of bid rigging that is going on, you have other types of crimes, whether it's public corruption or tax or other types. And it's been a big focus for us in the United States. And I understand it's continuing to be and highly emphasized in putting resources at the Justice Department. But the types of information that is exchanged in that can raise a whole new set of, criminal sanctions in the public procurement space. So that is another area, but that now you're getting clearly into the criminal space if you're exchanging the type of information to, either inflate the prices that the government is paying or some other types of anti-competitive effect on that. Related to that, an important agricultural product for us in the United States, and I'm sure in Brazil, in beef and grains, our federal laws, in order to stabilize supplies, have required certain kinds of information to be publicly made available through the Department of Agriculture. One of the things we've seen is just the mere fact of that type of requirement has caused prices to stabilize and minimize competition. It's a focus in the United States for policymakers about, when you're having that kind of information being mandated to be changed, a lot of times it leads to lack of competition. Now, it might lead to, greater stabilization within some markets, but that's a big policy consideration that we're seeing. So to the extent that CAGE and other agencies advise your government in your policy setting process, that's an important factor for them to consider when they mandate this type of information through the government.
Great. So this, in a limit, can be considered a kind of a safe harbor, if you consider it this way, if you have government involved on that, or at least sponsor that, right? So I do have a question, but we have 20 minutes, so I would like to open for the audience. We do have a question on a Q&A. What are the views in Europe, in Brazil about the exchange of public information between competitors? Public information, although normally not problematic, when it could be considered an issue. Commissioner, you want to start?
As I said, I think it all comes down to the proofs that information caused a damage to the market. And in my opinion, I have to say that Brazil has a very efficient public bid system. So if a competitor is bidding against the other, and it comes down that he knows the price that was offered by his competitors, it's easy to imagine or to calculate the costs of that competitor, including, for example, even the salary that competitor pays to its staff, what is the margin of profit that he's dealing with. So I think in Brazil, we have to be very serious and very constrained about proofs and damages, because without that binomius, we cannot say that that conduct is illegal, nor it may be sanctioned.
Sabine, do you want to comment? Please.
Yes. There have been cases, and the banana case, the weather conditions that you were concerned about, Patrícia, is possibly a telling case, because a lot of information they exchanged was public information. Where are the ships with the bananas? What are the weather conditions in the farming regions? What can we expect to happen in the future? That's basically information that was available to all of them. However, here also the court found, and of course, it went along with pricing information, so it was not a standalone thing that was being fined. But the general rule is, or what you need to consider is, does the exchange and the assessment of the information by the competitors and their exchange about it change the nature of the information? So that can change the nature of the exchange. It's then not just public information on anything. We talk about the weather when we're meeting at a trade association meeting, but we give our evaluation. What does it mean for business on top of that? So that can make a difference. It can also make a difference, and that's how the Commission puts it in their guidelines. If you put together like genuinely public information, but in a way that would be costly to compile for others, and share that so compiled type of information, because that also changes the nature of the information, and it has the potential also to exclude others who are not part to that kind of information exchange if they're not part to the same type of specifically aggregated and put together information. And in these cases, it can be seen as problematic, but that certainly also requires a closer and effects analysis.
Megan, do you want to comment?
I don't really have much to add to that, other than what we've said.
Okay. We have any other question? Yes, Lauro?
Well, thank you. Thank you all for the and going back to public procurement rules. Here in Brazil, the same conduct may be considered illegal in accordance with the competition law and the public bids law. So we have the, let's say, the exchange of information in one specific bid could be considered an administrative illegal by CADE, and let's say a criminal offense by the courts, or even by the administrative bodies that rules the public bid. So my questions for you foreigners is does this happens also in Europe or in the United States? And for Commissioner Lenisa, if she has dealt already with this same situation here, meaning that if this is a public bid infraction, fraud, and not, let's say, to be considered anti-competition infringement. What are your views on that? Thank you.
Yeah. Well, so cartel is a crime that is defined in criminal legislation. So when we face cartel in public bidding, more frequently will be a sanction in the penal area with over a due process of law. So cartel is a direct infraction. We have nothing to question about that. And cartel does not depend on intent or any other variable that we are discussing here regarding exchange of information. But I think that we have to analyze the conduct through two bias. The penal area, where you have specific proofs to make and we can presume a certain intent, then from the administrative point of view, that here we have to rely on the proofs, and we have absolutely to identify a damage in the market. We have to have a proved loss. We have to have damages. So I think that is very frequent that we have different opinions about the same conduct. I don't think I answer your question, Mr. Lau.
Megan,
Sabine, wanna comment on anything?
Sure. In the United States, we have a similar type of parallel prohibition against this type of fraudulent activity. In the United States, we have, in addition to antitrust, if you can meet the standards for the antitrust violation, you can certainly violate that if there's information exchanges to create a kind of a bid rigging claim. But you also have what's called the False Claims Act, which the Justice Department and private parties can enforce. And the same exact conduct could lead to, what would be called a false claims of an increased price to the government, even if it doesn't meet an antitrust standards, but somehow there was a fraudulent activity that meets that. So you can violate that. The Justice Department Civil Division enforces that type of conduct. And then, of course, you can, if there's, fraudulent activity under the wire fraud or telephone fraud, you can be found criminally liable, even if it's not an antitrust case. If you could put together the standards for that. Obviously, the government has a very high burden to prove the illegality of that kind of conduct under our due process and constitutional standards. But but we do have the duality, particularly when it comes to public procurement.
Thank you. Any other question, comment from the audience? Sabine, do you want to comment? I'm sorry, very sorry.
Yeah, thank you. Just briefly, European law, it's basically these systems run in parallel, but are actually increasingly interlinked in as if you have collusion in a tender, that's a ground for exclusion under procurement law. And you may know that there's also a European procurement directive. So the procurement laws in the European countries look very much alike. So collusion can be a ground for exclusion and for canceling the tender. So that's an option. However, where it gets muddled is when actually who has to say there was collusion. And some member countries, it is the procurement authority that has to decide we have sufficient indications of collusion, which is impossibly hard to do. In others, they have to wait for a decision by the competition authority. So there's still large discrepancies, but basically collusion, the competition offense, and then has a consequence under procurement law, which will be exclusion and possibly also debarment from public tenders. So if you're found guilty for collusion, you can be debarred, and it can take some time unless you conduct certain self-cleaning measures before you're being readmitted. Thanks.
Thank you. Cesar Matos.
Thank you. Conventional oligopoly models account with information. If you think about Bertrand or Cournot in economic theory, they count with information, a lot of information that you have to have about the costs or demand of the other players. So in some sense, the exchange of information can help you to achieve a competitive equilibrium, not only cartel or coordination. So how do you, is there some, can you make this separation when you are using information to improve the speed of convergence to this competitive equilibrium instead of a cartel equilibrium?
Oh, I think that's what I've said. In Brazil, we have to prove the damage. If not, I think that is very easy to say that is a safe harbor for this type of conduct when we can confirm that its results are positive and in the end of the investigation. But I think that's a very good question to Sabine, because European legislation is very assertive to consider it an infraction. So what happens if from that infraction we have a positive result? How do you deal with it?
Sabine, please.
Thank you very much. If you can prove a positive result, that would amount to showing that there are efficiencies of the conduct, and that's basically Article 101, paragraph 3, meaning if you can really show that there is a benefit, that there is efficiencies, better production, consumers do benefit, not just the companies, and the competition isn't eliminated, this can actually be put in the balance against the possible anti-competitive effects and can outweigh it. And so this defense can be made. But I think we don't even need to go that far, because that's what I said in the beginning. Not everything is considered terrible and bad in terms of information exchange, even between competitors under European law. So by just focusing on that, that might create the wrong impression. But issues, and I think that was part of the question, if we talk about benchmarking, exchanging information about where we are, production processes, average costs, what have you, progress in methodologies, past prices, past quantity exchange, this will not be considered inherently harmful. That would, if any, require an effects-based analysis. But if we're talking, for example, aggregated data that isn't too young, that isn't forward-looking, then in most cases it will not have a harmful effect, and that can actually lead to this kind of equilibrium in the market by benchmarking and measuring each other against what the others do on the market.
Perfect. Megan, do you want to comment?
No, but I mean, the econometrics tests are important because for us, it gets to the very first threshold question of, is there an anti-competitive effect? But it could also show that there's a legitimate purpose for doing so. But that'll go to that very first element of the test if you can show that the type of conduct does not have it. For example, if it's not a highly concentrated market, then the Cournot test or others will show that it won't have the same type of effect as if it was, three parties participating in a market. And of course, we have recognized in the U.S. that, certain kinds of buying, again, in the healthcare guidelines, it allows for some group purchasing organizations, even though it tends, depending on the market structures, it could tend to monopsonistic effects. But if it's not highly concentrated, we have shown that there's efficiencies by pooling together, warehousing information, processes for that purchasing in hospitals and others. So if you can show that, then it is not, it could defeat any kind of a challenge under the antitrust law.
Yeah, possibly also to provide some comfort here under European law. It's not a regular a block exemption, but it provides kind of a safe harbor when it comes to proceedings with the European Commission. So in the guidelines, we have also purchasing agreements where there is a safe harbor if the market share doesn't exceed 15%, if I'm not completely mistaken, and there is no hardcore provisions. What I said in the beginning, price fixing or quantity fixing involved, then you're also completely safe. So there's a lot of recognition that there are actually beneficial types of exchanges.
Great. So we are in the end of our panel. I'd like to thank the speakers for their expert contribution and this worthwhile discussion. It was a great pleasure to share the stage with you. I sincerely hope that next year, we can all be physically together here, have this room full of friendly people, friendly faces. Thank you, IBRAC, the translators, the organizers of this seminar, and of course, our wonderful audience, physical and virtually participants. Thank you, Sabine, Macon, of all this, not the contribution, but for the work we have done together. A gente tem uma mensagem agora da WIA, the Women in Antitrust. Nossa querida, admirada por todos, Amanda, uma das fundadoras do grupo. É um prazer ter você aqui.